Hello, I'm Kenneth Marcus, founder and chairman of the Louis D. Brandeis Center for Human Rights Under Law. I'd like to welcome you to this event in the Louis D. Brandeis Center Summer Speaker Series. Today, we are featuring Professor Lesley Klaff and Rabbi Dr. Mark Goldfeder on the topic of law and Jewish identity. This issue has been a big one for the Brandeis Center throughout its 10-year history, and for me, even beyond that. It's been an issue for me, formerly as head of the US Department of Education's Office for Civil Rights, because for many years, the federal government declined to protect the civil rights of Jewish students on the basis that Title VI of the Civil Rights Act of 1964 prohibited discrimination on the basis of race, color, or not national origin, but not religion. And the question arose, are Jews a religious group, or are they also something else? A race, a national origin, or perhaps a group sharing ethnicity and ancestry. For the last several years, although not consistently, the federal government, based in part on documents that I issued, guidance that I shared, have established that Jewish students are entitled to certain protections under Title VI because Jews may be not only members of a religious group, but also people who should be viewed as sharing ethnic or ancestral background for purposes of civil rights law. But that has not always been recognized, and the stakes have sometimes been high. During certain periods, the difference between whether Jewish students receive protections under our federal civil rights laws or not has depended on whether Jewish students are understood to share something more than just a religion. Now, some will argue that even if it's just a religion, that religious discrimination is bad enough and the federal government should step in. But as a matter of law, not every civil rights statute includes religion, and for that reason, it sometimes makes a difference. We have two scholars here who have thought about these issues and who have important backgrounds both in their writings and in their active work, and who can shed light not just on this issue as it arises in US law, but also in the law of the United Kingdom and perhaps elsewhere. Professor Lesley Klaff, for instance, is a senior lecturer in law at Sheffield Hallam University. She's also a leading scholar of anti-Semitism and is, for example, editor of the Journal of Contemporary Anti-Semitism and associate editor of the Journal for the Study of Anti-Semitism. She's also been a member of various academic advisory boards. I'll mention just one. I'm proud to say that she has been for several years a member of the advisory board of the Louis D. Brandeis Center for Human Rights Under Law. Now, Rabbi Dr. Mark Goldfeder is familiar to many members of our audience, I imagine, because he has joined us as recently as just a few weeks ago in a lecture which has gotten high praise from those who had the privilege of participating. You may recall that he is director of the National Jewish Advocacy Center and Special Counsel for International Affairs at the American Center for Law and Justice. He has served as the founding editor of the Cambridge University Press series on law and Judaism, a trustee of the Center for Israel Education, and as an advisor to the permanent mission of Israel to the United States. Both of them have numerous other honors and publications and activities that also reflect their stature as leading figures, both in the academic aspect and also the practical side of dealing with the problem of anti-Semitism. I'll be pleased in a moment to welcome first Professor Klaff and then Rabbi Dr. Goldfeder. I will refer members of the audience, though, to the Q&A button that appears at the bottom of their screens. At any time, please feel free to add Q&A questions or comments, and we'll review them later on. I also want to say that we will be joined after Lesley Klaff and Mark Goldfeder's remarks by my colleague, Eliza Lewin, president of the Brandeis Center, who will join us for discussion, may have comments of her own, and will join us for Q&A as well. With that, I'm happy to express our gratitude to both speakers in advance and to welcome Professor Lesley Klaff.
Okay, thank you very much for that very generous introduction, and also for the invitation to speak at the Louis D. Brandeis Centre. It's a very great privilege to be here. I'm going to talk about law and Jewish identity, and as Ken said, the legal construction of Jewish identity is important because it determines what legal protection Jews get from discrimination, harassment, and victimization. So I'm going to look, obviously I'm going to look at it from the British point of view, and I'm going to look at two UK statutes to see how Jewish identity was constructed with respect to those statutes. The first one is the Race Relations Act of 1976, and the second is the Equality Act of 2010. The Race Relations Act of 1976, which built on two earlier statutes of the same name, was passed to make it unlawful to discriminate against someone on if they were a member of a racial group, whether in education or employment or in the provision of goods or services. And it was said obiter dicta in a case called Mandler and Dowell-Lee that Jews are a racial group. I'll explain how that came about. The statutory definition of racial group under Section 3 of the 1976 Act defined racial group as a group of persons defined by reference to colour, race, nationality, ethnic, or national origins. In the case Mandler and Dowell-Lee, which went to the Court of Appeal in 1982, this case concerned an Orthodox Sikh boy who was refused admission to a private school unless he removed his turban and cut his hair in order to comply with the rules on school uniform. He lost the case at the trial level. He had to prove, in order to get the protection of the Race Relations Act, that he was a member of a racial group as a Sikh. And the case was specifically put on the grounds that he, as a Sikh, could be defined by reference to his ethnic origins. He appealed to the Court of Appeal, which was the intermediate level appellate court. And although the court was not concerned with Jews, this was a case involving Sikhs, there was obiter dicta in the Court of Appeal by Lord Denning, who said in no uncertain terms that what distinguishes Jews from other people in England is that they have a racial characteristic in addition to having a different religion. And there are two long passages in the Court of Appeal decision where Lord Denning talks about Jews having a racial characteristic. He said that Jews are the best known example of an ethnic group. And what this means is, and I'll quote, it means that the group as a whole share a common characteristic, which is a racial characteristic. It is that they are descended, however remotely, from a Jewish ancestor. He then went on to say that, quote, I have no doubt that in using the words ethnic origins in the statutory definition of racial group, Parliament had in mind primarily the Jews. There must be no discrimination against the Jews in England. Anti-Semitism must not be allowed. It has produced great evils elsewhere. It must not be allowed here. He said that Sikhs weren't defined by reference to their ethnic origins, so there was an appeal taken to the House of Lords, the final appeal court, and the House of Lords overturned the decision with respect to Sikhs, but also again gave dicta that Jews are members of a racial group. And the House of Lords gave a broader definition to ethnic group, which requires, there are two essential characteristics to be a member of an ethnic group. One is a long shared history. The other is a cultural tradition, including religious observance. And then there are some relevant characteristics, including a common geographical origin or descent from a small number of common ancestors. Others were a common language, not necessarily peculiar to the group, a common literature, a common religion, and being a minority in a larger community. So since that dicta in Mandra and Dao Li, it has never been contested that Jews are a race as well as a religion for the purposes of the law. I'm now going to look at the legal construction of the protected characteristic aspect of the Equality Act 2010. So just to say that the Race Relations Act was repealed by the Equality Act of 2010. The Equality Act is a consolidating statute which consolidates all existing anti-discrimination law in the UK. And the statutory definition of racial group in the Race Relations Act is now in the Equality Act, Section 9. The Equality Act protects people from discrimination, harassment, and victimization in education, in employment, in the provision of goods and services, and in other public sector bodies, if it's related to a protected characteristic. So, Jews, following Mandla and Dao Li, Jews are protected as both a race and as a religion or belief. There are 9 protected characteristics altogether. Others include age, disability, sex, sexual orientation, pregnancy, age, marital status, gender reassignment, and so on. But race, religion, or belief apply to Jews under the Act. So what we want to think about now is whether the law recognizes Israel as an aspect of Jewish identity. And this has been tested under the harassment provision of Section 26 of the Equality Act 2010. Under Section 26, harassment is defined as unwanted conduct related to a protected characteristic which has the purpose or effect of violating a person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for him. So the statutory tort requires 3 things. 1, unwanted conduct. 2, that it's related to the protected characteristic, in our case being Jewish, which is a race and a religion. And 3, that it has the proscribed purpose or effect. So this Section 26 is important because, as we know, a lot of contemporary anti-Semitism is in the form of extreme hostility to Israel and anti-Zionism. And there have been some claims made under Section 26 of the Equality Act by Jewish claimants, claiming that anti-Israel hostility in a particular organization or in a university has created a hostile environment which has harassed them as a Jew. So, what we need to establish in these kinds of cases is that the decision maker recognizes that the unwanted conduct, the hostility to Israel or to Zionism, is related to being Jewish, to the protected characteristic of being Jewish, because that's the first step in finding harassment. So the first case we're going to look at, which was heard in the Central London Employment Tribunal in 2012, and their judgment was delivered in 2013, is Fraser and the University and College Union. the University and College Union is the largest academic union in the UK for university and college professors. And Ronnie Fraser is a retired mathematics professor who took a complaint, who sued the University and College Union, the UCU, for institutional anti-Semitism, claiming that this harassed him as a Jew. And the complaint was made under Section 26 of the Equality Act 2010. Now, Fraser alleged that the unwanted conduct were the repeated annual boycott motions against Israeli academics and no others in the world. This engendered a lot of hostility, lots of hostile discourse to Israel, both at the debate, during the debates when these motions were discussed at annual Congress, and on social media, on the activist lists, and really did create a hostile environment for Jewish members of the union. I was one of Ronnie Fraser's witnesses. He had 34 witnesses, and we were represented by Anthony Julius, who you may have heard of. He's quite a famous lawyer in Britain, and he took the case pro bono. So Anthony Julius put the case as follows to the tribunal. He said, Mr. Fraser has a strong attachment to Israel. This attachment is a non-contingent and rationally intelligible aspect of his Jewish identity. It is an aspect that is of his race and/or religion or belief. The fact that not all Jewish people have the same views does not prevent it from being an aspect of the protected characteristic. A significant proportion of Jewish people have an attachment to Israel, which is an aspect of their self-understanding as Jews or Jewish identity. So that required the tribunal to accept that among other things, that the hostility to Israel was related to Ronnie Fraser's Jewish status. And in fact, the tribunal accepted that the related to test in Section 23 denotes a loose associative link between the behavior under consideration and the protected characteristic. The UCU had tried to argue that the related to meant on the grounds of, so that the unwanted conduct had to be on the grounds of race or religion. But the tribunal said, no, there just has to be a loose associative link. And the tribunal actually said, and I quote, "It seems to us that the practice of repeatedly criticizing the actions and policies of the United States could certainly be seen as related to race." Despite that, the tribunal went on to declare that an attachment to Israel is not intrinsically a part of Jewishness. It actually said, quote, "It seems to us that a belief in the Zionist project or an attachment to Israel is not intrinsically a part of Jewishness." So they refused to recognize that the criticism of Israel, as they saw it, was related to the protected characteristic of being Jewish. And the reason why the employment tribunal came to that decision, purportedly, was because of some of the witnesses for the University and College Union were anti-Zionist Jews who were hostile to Israel. And the tribunal very pointedly said, quote, "The complainant's main contention is that the conduct of which he complains was inherently discriminatory in that it consisted of acts and omissions concerning the conflict between Israel and Palestine, and so related to his, although of course not every Jew's, Jewish identity, and as such his Jewish race and/or religion or belief." And the his was italicized both times in the judgment for emphasis. So we lost the case, and we lost it on several grounds. So now I'm going to look at, just to say that decision does not set, it doesn't set precedent. It was a decision of a trial court. The employment tribunal was just the trial level, and it doesn't establish precedent. The next decision I'm going to look at is Parker and Sheffield Hallam University, which was decided by the Office of the Independent Adjudicator in 2016. So this was not a decision of a court. This was a decision of a statutory body, which was set up under the Higher Education Act of 2004 to review the way that universities handle complaints brought by students. So this case involved a Jewish graduate student called Yehuda Parker at my university, where I lecture law, who lodged a complaint against the university, complaining that the social media activity of the Student Palestine Society, which consisted predominantly of blood libels and Nazi analogies, harassed him as a Jew on campus. And so he said it created a hostile environment for him, and he was afraid to mention Israel. He was afraid to wear his yarmulke or to show his Magen David. He's quite Orthodox. And he was afraid even to step foot on campus during Israeli Apartheid Week. Just to say that this complaint was filed in 2014 in the aftermath of Operation Protective Edge. So you can imagine how bad the Palestine Society's social media activity was. The university dismissed the complaint. They said that Mr. Parker had conflated anti-Zionism with anti-Semitism. And they said that although the material he complained about was provocative and controversial and even offensive, it wasn't anti-Semitic. We'd also invited the university to use the working definition of anti-Semitism as a guide to determining whether the material he complained about did cross the line into anti-Semitism, and the university refused to do that. Just to say that myself and another lawyer who does work for UK Lawyers for Israel helped Mr. Parker with his complaint and his appeal. So after the dismissal of the complaint, we appealed to the Office of the Independent Adjudicator, claiming that the university had unreasonably failed to engage properly with his complaint. And the OIA, as we call it for short, which reviews the way the university handles the complaint, actually upheld our appeal. They said our complaint to them was justified. And they said that we are, and I'm quoting here, among other things in their report, they said, we are not satisfied that the university properly turned its mind to the question of whether Mr. Parker, as a student identifying as Jewish, was likely to have felt harassed as a result of some of the material. So that seems to give implicit recognition to the idea or the view that Jews have an attachment to Israel. The OIA also endorsed the use of the working definition of anti-Semitism. It said that the working definition of anti-Semitism was, in our view, relevant to the question of whether material which purportedly was criticizing the alleged actions of the Israeli state crossed the line from being merely offensive or inflammatory to Mr. Parker to amounting or potentially amounting to material which might reasonably be perceived as anti-Semitic and likely to cause Mr. Parker, as a student identifying as Jewish, to experience harassment. So here we have, again, it's a decision of a statutory body. It doesn't form binding precedent, but it interpreted the law, section 26 of the Equality Act, and it constructed Jewish identity for the purposes of it being a protected characteristic in a way that recognized the Jewish attachment to the State of Israel. And finally, I'll be brief, I won't take long with this, just very finally, I'm going to now want to look at the report by the Equality and Human Rights Commission on anti-Semitism in the Labour Party. This report was published on the 29th of October 2020. The Equality and Human Rights Commission is a statutory body which has been given powers under the Equality Act 2006 to force compliance with the Equality Act 2010. I'm sure you've all heard about the anti-Semitism which became normalised in the Labour Party after Jeremy Corbyn became leader in 2015. Much of this anti-Semitism was in the form of extreme hostility to Israel and to the Zionist project. And much of it occurred on social media. There were a lot of complaints about the anti-Semitism, but that just engendered further anti-Semitism because it was alleged that the complaints were made in bad faith to smear the Labour Party. So the aim of the investigation was to determine whether the Labour Party committed a breach of the Equality Act 2010 against its members, associates or guests through the actions of its employees or agents. And what's interesting about the Commission and its report is that the Commission investigated unlawful acts of discrimination or victimization relating to race or religion, but specifically said that the Equality Act defines harassment as unwanted conduct relating to Jewish ethnicity. And this is something that the Employment Tribunal hadn't done and the Office of the Independent Adjudicator hadn't done. And this suggests that the Commission understood the broader ethnic and national dimension to Jewish identity, and it opened the door for them to find that criticism of Israel, certain criticism of Israel, harassed Jewish members of the Labour Party. On the question of free speech, Article 10 of the European Convention of Human Rights, which applies in domestic law here by virtue of the Human Rights Act of 1998. Article 10 is the free speech article. The Commission said Article 10 of the European Convention of Human Rights will protect Labour Party members who, for example, make legitimate criticisms of the Israeli government. It does not protect criticism of Israel that is anti-Semitic. Where we refer to legitimate criticism of Israel throughout the report, we mean criticism that is not anti-Semitic. And so the harassment that they found, they identified certain social media statements, which included comparing Israelis to Hitler or the Nazis, claiming that complaints of anti-Semitism were manufactured by the Israel lobby, blaming Jewish people for the actions of the State of Israel, accusing British Jews of greater loyalty to Israel than to Britain, using Zio as a term to refer to Jews, accusing Jews of crying anti-Semitism in bad faith to prevent Israel from being criticized, and so on. So what happened was the Commission issued 2 unlawful act notices to the Labour Party. One was specified to be a notice that the Labour Party committed unlawful harassment of its members. contrary to section 101, subsection 4 of the Equality Act, related to Jewish ethnicity. And the other was an unlawful act notice to the Labour Party with respect to the complaints handling process. They found political interference in the anti-Semitism complaints and failure to provide adequate training for those handling the complaints. And they said that this was unlawful indirect discrimination against the party's Jewish members. That was contrary to the Equality Act. So just to conclude, the Equality and Human Rights Commission seemed to understand the broader national and ethnic dimension to Jewish identity, just as the Mandler and Dowell League Court had way back in 1982 and 1983, and found that illegitimate criticism of Israel or anti-Semitic criticism of Israel amounted to unlawful harassment of Jewish members of the Labour Party, based on its interpretation of the Equality Act and of Article 10 of the European Convention of Human Rights. So this does appear to give recognition to Israel and the Zionist project as an aspect of Jewish identity, but we should exercise caution in claiming that the Commission's construction of Jewish identity amounts to a general principle of law, because this was not a court of law, and it's not binding precedent. It was a statutory body, but it will be highly persuasive. Okay, thank you very much.
Thank you, Professor Lesley Klaff. And now Rabbi Dr. Mark Goldfeder.
Hi, can you hear me?
Yes.
Great. First of all, I want to just say thank you to the Brandeis Center, to Ken and Eliza for the invitation. Law and Jewish identity is a complicated question for a number of reasons. To begin, and to borrow, I guess, a modern term, Jewish identity can be composed of many different intersectional parts, right? Yes, Judaism is a religion, but it's also race. It's also a nation. It's also an ethnicity. It's also a culture. And there are Jews who fall on all different parts of each of these spectrums. And that's just how Jews define themselves, right? There's also the very serious problem of how other people tend to impose definitions of what Jewishness means on Jews. And that's really where we come to anti-Semitism, because while anti-Semitism itself is a mutating virus, one of the main unchanging symptoms is the attempt by anti-Semites to redefine Jewishness in any given era as something that's not worthy of protection by societal standards, or even, as we're going to discuss today, by law. You know, even the term anti-Semitism itself reflects this problem, as opposed to, say, anti-Jewish. Why not the term anti-Jewish? In 1879, Wilhelm Marr popularized the term anti-Semitism, and according to his biographer, it became popular precisely because of its scientific pretensions. It's somewhat a vague term, it's good cover against legal suits, and it casts a cloak of uncertainty over the intent of Jew hatred. So basically, anti-Semitism served the same purpose which the term anti-Zionism serves today, right? It helps the accused evade the accusation of engaging in something improper. Okay, but in terms of its focus, anti-Semitism tends to look at Jews as a collective identity, right? The idea being that individual Jews might be tolerable, but Jews as a separate collective identity should not be allowed to exist with the same rights as other groups. Again, going back to Wilhelm Marr for a second, when he founded the League of Anti-Semites, a real thing, he wrote that not individual Jews, but the Jewish spirit and Jewish consciousness have overpowered the world, right? Hints of Ilhan Omar. That's why the majority of anti-Semitism in any given era tends to focus on the primary form of collective Jewish identity at that point in time. Rabbi Jonathan Sachs famously said, throughout the Middle Ages, Jews were for the most part a religious community, and so they were hated for their religion, even if the particular Jews that were being oppressed were not religiously Jewish themselves. In the 19th and 20th centuries, when many Jews became secularized, the primary unifying collective identity of Jews was their ethnicity, and so the hatred mutated to focus on race, even when the assimilated Jews that were being oppressed only had a trace amount of Jewish blood. Just take a look at the Nuremberg laws. And today, when the primary collective embodiment of Jewish people on the planet really is the state of Israel, Jews around the world are hated and held accountable for their state, even if they're not Israeli. Again, just take a look at the last couple of months in America. For anyone who's still pretending that anti-Zionism is unrelated to anti-Semitism, May and June should have been both clarifying and embarrassing. In each instance, though, throughout history, the essence of anti-Semitism has remained the same, right? Even if the focus somewhat shifts, it's anchored in the denial of the legitimacy of the Jews as a separate collective identity. And so now we come to the law, because the government is required to protect its citizens from harassment and invidious discrimination. And anti-Semitic harassment is theoretically illegal. Aside from a variety of more explicit state anti-discrimination laws, Title VII with the Civil Rights Act protects employees against many forms of discrimination, including specifically religion. Title VI protects students from discrimination based on their race or national origin. And the problem, again, traditionally was fitting Jewish identity into those legal boxes. It was a problem until the Honorable Ken Marcus came along. And again, it feels weird to talk about this topic with him on the line, because we really owe him and the Brandeis Center so much in this regard. But for those of you who don't know, I'll give you a little bit of background, and Ken mentioned it briefly in his introduction. But, again, in the United States, Title VI of the Federal Civil Rights Act requires recipients of federal funding to ensure their programs and activities are free from harassment, intimidation, and discrimination on the basis of race, color, and national origin, but notably it doesn't include religious bias. And so until 2004, the Office of Civil Rights, OCR, typically refused to investigate anti-Semitism complaints because Jews are a religious group and not a race or national origin. And then in 2004, then Deputy Assistant Secretary of Education for Enforcement, Ken Marcus, issued a series of policy statements which explained that they would henceforth investigate anti-Semitism complaints to the extent that they also implicate ethnic or ancestral bias. And again, the logic here is very clear. Much of the hatred embodied in anti-Semitism has nothing to do with specific religious practices and everything to do with ethnicity or ancestral bias, right? Generally, people don't hate Jews because they do or don't light Shabbat candles on Friday evening, but they do sometimes hate them even today for their quote unquote race, meaning their ethnicity or their national origin. And Ken's reasoning has been confirmed in Title VI cases and in the Title VII context as well. But the real question, I think, today is this new old form of anti-Semitism, because whether we like it or not, people see and treat Jews around the world as Zionists. And at the core of that issue is a question about how Zionism does or does not fit into the idea of Jewish identity. So let's start with some easy ones. When is criticism of Israel anti-Semitic? Well, when proponents use classic anti-Semitic tropes and stereotypes to discuss Israel as a collective Jew among the nations, right? That's a proxy for how anti-Semites would talk about Jewish individuals. So for example, when they accuse people of Jewish conspiracies, or they accuse Israel of blood libels, or they portray Jews, generally not even Israelis, but mostly Hasidic looking Jews, as satanic, demonic, and evil when discussing Israel, or accusing Jews of dual loyalty, or engaging in Holocaust denial and Holocaust inversion. When that happens, the symbols used often belie the speaker's true intent, right? That's anti-Semitism. But sometimes it's not as obvious to a casual observer. And that, by the way, just as a side point, favorite topic of mine, that's why there needs to be a definition to assess context and motivation. And again, I'm preaching to the choir here, but that's why anti-Semites don't like the International Holocaust Remembrance Alliance definition of anti-Semitism, because it includes examples of problematic anti-Zionism, and it takes away their freedom to push past the line. So here's some easy ones again. In practice, practically speaking, denying world history to claim that Jews are not indigenous to Israel, or denying only the Jewish people their right to self-determination, or calling for the elimination of the world's only Jewish state, which includes ethnic cleansing of the region and or the genocidal extermination of the millions of Jews who live there. Those are all examples of things that are also likely to be anti-Semitic depending on the circumstances. Okay, and when criticism of Israel is done in a discriminatory manner, meaning when Israel is singled out for disparaging treatment, not for what it's done, but simply for what it is, a Jewish state, that is anti-Semitism, and it should not be taken lightly for two reasons. First of all, it's ethically objectionable, but second, it's also very dangerous. In terms of the ethics, This modern form of anti-Semitism is morally indistinguishable from the historical forms of anti-Semitism we talked about before. Like the earlier examples of religion and race, anti-Semitic anti-Zionism focuses on the idea of collective Jewish identity. Yossi Klein Halevi has a great quote. I'm going to pull it up 1 second. Yeah, he says about anti-Zionism and anti-Semitism, what anti-Semitism does is turn the Jew into the symbol of whatever it is that a given civilization defines as its most loathsome qualities. Under Christianity, before the Holocaust in Vatican II, the Jew was the Christ killer. Under communism, the Jew was the capitalist. Under Nazism, the Jew was the race polluter. Now we live in a civilization where the most loathsome qualities are racism, colonialism, apartheid, and lo and behold, the greatest offender in the world today, with all of the beautiful countries in the world, is the Jewish state. The Jewish state is the symbol of the genocidal, racist apartheid state. The state of the Jews has become the Jew of the states. Now, I'm sure many of you in this context are familiar. Unfortunately, this kind of treatment is often on display at the United Nations. You know, for example, the UN Human Rights Council was established in 2006, in theory, to address human rights issues around the world. In its first year, 100% of its condemnatory resolutions, 9 of them, targeted Israel. To this day, Israel is the only country in the world that has a permanent agenda item dedicated to it. From 2006 to 2016, over 50% of all human rights resolutions were targeted at Israel. In the UN Commission on Human Rights, half of all resolutions are targeted at Israel. And the General Assembly is even worse. This past year alone, in the 75th session of the UN General Assembly, 2020-2021, there were 17 resolutions against Israel and 7 about the rest of the entire world combined. So you can see it happening at a macro level, but it also happens at a micro level when individual students and student groups are singled out and discriminated against because of their stated or even sometimes assumed support of Zionism. I want to be perfectly clear here. It doesn't matter how you define anti-Zionism. Any anti-Zionism that allows for discrimination against Jewish people and or their allies because of their affiliation with or affinity for or support of the biblical, prophetic, historical, ethnic, cultural, Jewish ideal of Zionism is anti-Semitism, period. Take a step back. What is Zionism? Zionism is the movement for the reestablishment and really now the development and protection of a Jewish nation in its ancestral homeland. And discriminating against a Jewish person or group because they are Zionist is illegal because Zionism is not just a political movement. For the vast majority of Jewish people across time and space, it has always been an integral part of their Jewish, often their religious identities. You know, from a Jewish law perspective, over half of the biblical commandments that religious Jewish people are bound to obey are specifically tied to Israel as the Jewish homeland. From a doctrinal point of view, belief in and hope for the return to Zion is literally part of the 13 principles of Jewish faith. The bottom line is that for many, if not most Jewish people, Zionism is a fundamental Jewish belief, and discriminating against someone for their religious belief or their ethno-religious identity is wrong. Again, I have to say that speaking about law and Jewish identity and anti-Zionism at the Brandeis Center is an honor, because the quote I love to give when I talk about anti-Zionism and anti-Semitism is from Eliza Lewin, who will be joining us next. And I'm going to pull up her quote now because it's really worth repeating. She said that Zionism is as integral to Judaism as observing the Jewish Sabbath or maintaining a kosher diet. Not all Jews observe Shabbat or Kashrut, but those who do so as an expression of their Jewish identity. Similarly, not all Jews are Zionists, but for many Jews, identifying with and expressing support for the Jewish homeland is also an expression of their Jewish religious and ethnic identity. Harassing, marginalizing, demonizing, and excluding these Jews on the basis of the Zionist part of their identity is just as unlawful and discriminatory as attacking a person for observing Shabbat or keeping kosher. It's comparable to demanding that a Catholic student disavow the Vatican or that a Muslim student shed his or her connection to Mecca. Excluding an individual in this manner on the basis of his or her identity is discrimination. It demands that Jews shed a key component of their identity as Jews namely the historic Jewish yearning and determination to return to Zion. Right? Can't really put it any clearer than that. But it's also clear from a legal perspective that anti-Zionist discrimination functions as anti-Jewish discrimination under what we call a disparate impact analysis, right? That's a legal measure which ignores the motivation and it looks at the discriminatory effect of a given action or policy. There was a recent Gallup poll that found that 95% of American Jews support Israel, which, by the way, is the definition of Zionism that tends to get Jewish students and Jewish groups excluded around the country, even if they disapprove of some or all Jewish Israeli policies. But again, by the way, the research is also clear, as Eliza proved, that religion plays an important part in those beliefs, right? The studies back that up. But even if that part was not so clear that it was religious, if in practice, a policy has the effect of excluding or demonizing 95% of a group based on their shared ethnic beliefs, then it should be obvious that you're discriminating against that group and against their beliefs. And again, this hatred is dangerous because study after study has shown that discriminatory rhetoric eventually leads to action. And these studies have been confirmed each time allegedly non-anti-Semitic, anti-Israel activism breaks through that non-violent veil and people get hurt, or each time that student groups start by demanding that Jews leave campus and end up threatening violence if they don't. And what's interesting, though, particularly for the time we live in, is that while people like Ken and Eliza have been working on these issues for years and warning about the dangers, now they don't need to bring those studies up because we have all literally seen it over the last couple of months in countries around the world. Anti-Semitic attacks have shot up over 400% since the most recent outbreak of violence in the Middle East. Again, in America and cities across the country, Los Angeles and New York, hundreds of synagogues and Jewish community centers and kosher restaurants and Jewish-owned businesses and individual Jewish people have been targeted and attacked and beaten and bullied and cursed and demonized, all because they're Jewish, even in some instances as they were screaming that they did not support the state of Israel. So there's no clearer demonstration than the recent events that we've all seen with our own eyes, that Judaism and Zionism are related and they're core parts of Jewish identity. And that's also, again, just to beat the horse, as why we need the International Holocaust Remembrance Alliance of definition, and why that definition includes examples of problematic anti-Zionism, such as, for example, holding Jews collectively responsible for actions of the state of Israel, which is ostensibly what led to all these recent spate of attacks. But what the last few months did really, for me, it brought to life a famous quote from Martin Luther King Jr., who once said that when people criticize Zionists, they mean Jews. You're talking anti-Semitism. To claim that Zionism and Judaism are completely separate identities is just to be ignorant, or as Dennis Prager would say, to pretend that Italy has nothing to do with being Italian. And so I'll turn it back over now because we have the two masters of the field, Ken and Eliza, who can probably shed even more light on that issue.
Thank you, Mark Goldfeder. Thank you both. And Mark, I appreciate the kind words. We have a little bit over 10 minutes remaining. And fortunately, as Mark has reiterated, we have the good fortune of being joined now by my Brandeis Center colleague, Eliza Lewin, president of the Brandeis Center, partner in the law firm of Lewin and Lewin, and past president of the American Association of Jewish Lawyers and Jurists. Eliza, do you have either thoughts or questions or any input to share on this? It would be surprising if you did not.
Sure. Well, first I want to thank you, obviously Ken, but thank you, Lesley, and thank you, Mark, for wonderful presentations. And Mark did, with my quote, take one comment that I had wanted to make sure was raised. But I think an additional gloss on this idea that not all Jews are Zionists, just like not all Jews observe the Jewish Sabbath. You do not have to yourself be a Jewish Sabbath observer to recognize and appreciate discrimination of Sabbath observers, right? If somebody is being marginalized or harassed or excluded because they are a Sabbath observer, you can understand and recognize that that's wrong, even if you yourself do not observe the Sabbath. By the same token, if somebody is being marginalized or dehumanized or excluded or physically attacked because they have expressed as a part of their Jewish identity, support and connection to the land of Israel, you do not yourself have to be a Zionist to recognize and acknowledge that that too is wrong, that it's unlawful harassment and discrimination. And I think that's really important. We're not asking people to become Zionists in order to recognize anti-Zionism as unlawful harassment and discrimination. We're just asking them to recognize that human rights, right, civil rights apply in this case, that for many, 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 in fact, most Jews, they identify with and feel this deep connection to the land of Israel. For many, it's religious, right? You just look at the prayers and you'll see that the Jewish prayers over the centuries pray for this return, pray for the Jews to once again, the ingathering of the exiles, for them to return to the land of Israel and reestablish the Jewish right to self-determination in their ancestral homeland. But even for those who are not observant, for those who are not religious, for those who maybe just look at the Bible as a history book, the idea that in Israel, Jews are walking on the same stones that the Jewish people walked on thousands of years ago, that it took place, that their history, their heritage, their roots took place here, just their history. They may have no belief in God, right, or practice religious observance of Judaism, but they too feel connected to this place. Or there may be people who just celebrate that there is this land, this small, tiny country, where the national calendar is actually the Jewish calendar. So you don't even have to really be paying attention, and you know when the Jewish New Year is, and when Yom Kippur is, and when Passover is, and when Sukkot is, because that's the rhythm of the country. And as a Jew, that's exciting. Or the ancient Jewish language of Hebrew is now a modern spoken language on signs and T-shirts and spoken all over the place. That's exciting. Right? And then when you see the Jewish people, when you see what Israel as a collective actually offers to the world, how it runs, it's one of the first to run to provide humanitarian aid and assistance, like we've seen now in Surfside and elsewhere. If there's ever a natural disaster, the Israeli team is one of the first on the ground. Or when it comes to issues like medicine and agriculture and high tech, the Jewish nation state is providing so much miracles every day to the world. So if you take pride in that, that often has absolutely nothing whatsoever to do with the Arab-Israeli conflict. That comes from your pride in your Jewish ancestral ethnic heritage, your Jewish identity. And what's happening today is that Jews are being pressured to shed that part, to be ashamed of that part of their Jewish identity. And they're being told, actually, if you want to be included, if you want to join us in terms of social justice efforts, you have to get rid of that part of your identity. That's the ticket to admission, is to shed or hide that part of your Jewish identity. That's discriminatory. That's what Mark was saying when he said, I say it's no different than saying to somebody, the ticket for admission is to stop observing your Jewish Sabbath, or to stop keeping kosher, or to a Catholic, disavow the Vatican before you can join our club, before you can join our social justice movement, before you can demonstrate with us on women's rights or LGBT rights or immigration rights or climate change issues or any of that. You first have to shed this part of who you are. And I think that what's happening today, and what Mark has said, is now it's years ago, the rhetoric seemed like just rhetoric and people misunderstood it for political debates. Today, we are actually seeing the consequence of not having responded forcefully to that rhetoric. Because what's happening today is the actual marginalization and exclusion. It's happening over and over again, particularly on campuses and beyond. And as Mark said, you also saw it after the last recent hostilities in Israel, between Israel and Gaza and Hamas. You saw it actually escalate to physical violence. And that's what happens. It's been shown over and over again throughout history. If you repeatedly target a community and you dehumanize them over and over and over again, you compare them to the worst of the worst, you say that they are beyond the pale, then what you've done is you've created an atmosphere where it's acceptable to treat that community not only in a discriminatory fashion, but ultimately to engage in violence. Because the world, right, that's the idea of anti-Semitism, the world would be a better place if not for the Jews. So let's exclude them. Let's get rid of them. The world will agree, because this is the community that is the cause of our misfortune, right? It's the community that's the source of the disease, or the source of all the ill, the problems, whatever it is we have. Get rid of the Jews and things will be good. People now are beginning to understand that. And people are now beginning to recognize that this form of discrimination is discrimination against Jews. You're on mute, Ken.
Thank you, Elisa. So with about 5 minutes remaining, we have time, I think, for one question. And the question for whomever wants to take it is the following. This is from the audience. Can anti-Zionists express their criticisms of Israel without being anti-Semitic? How can we ask our anti-Zionist peers and co-workers to express their criticisms in a way that does not create a hostile environment for Jews? What toolkit can we give them?
I'm happy to jump in first if you want to. And again, I'll take another page from Elisa's playbook here, but I'll differentiate between anti-Zionism, which is possibly has its own inherent problems in terms of anti-Semitism, from anti-Israel activity. And I'll say, now I'm speaking for myself, here's a general rule. Political anti-Israel activity is not necessarily anti-Semitic. Okay, so you can be anti any or even all actions of the Israeli government without crossing any line. Discriminatory anti-Israel activity that scapegoats the Jewish state the same way anti-Semites have always scapegoated Jewish people is not fine. And if that's what you're doing, that is anti-Semitism. In terms of a toolkit, I mean, the easiest way to deal is if you have a, again, if a coworker or someone, is have a conversation and ask them what they really mean by that. If it turns out that at the core, they think Israel should not exist, or Israel or the Jews alone among the nations aren't entitled to their own homeland and to their own ancestral roots, then maybe you have a problem. But it's possible that they just disagree with some policies. And so I would say go in with an open mind. And again, noting that Jewish people across the world, every cab driver in Israel is notoriously hostile to one or all actions of the Knesset. It doesn't mean that you're anti-Semitic, but when you think Israel shouldn't exist, or when you demonize it and delegitimize it, discriminate against it, that is anti-Semitism.
Thank you, Mark. Lesley, do you have any?
I think criticism of Israel, which criticizes the essential nature of the state, and constructs it as a prior state in order to justify its elimination, is anti-Semitic. So as Mark said, that any comment that is designed to go to the very nature of Israel, calling Israel a Nazi state or an apartheid state, or a settler colonial state, those claims aren't only not true, they're not only libelous and so on, or defamatory, but there is nothing Israel can do to correct those criticisms other than cease to exist as a Jewish state. I mean, those are kinds of criticisms that people who are trying to persuade everyone that Israel is an illegitimate state, that it should never have come into existence in the first place and should cease to exist now, advance. If, on the other hand, people criticize Israel's, some of its actions, some of its military actions, or some of its policies, which can be corrected by Israel, they don't go to the very essence of Israel. They don't construct Israel as an illegitimate state in its essence, then those presumably are not anti-Semitic. So, for example, there was criticism that in the first Gaza campaign in 2008, 2009, Israel used white phosphorus, and that was reported on, and as a result, Israel responded to that and now has declared that it doesn't use white phosphorus anymore. So I mean that criticism, I think if you say the settlements are illegal, you can have a back and forth about that. There's room for disagreement, room for a debate, but it doesn't go to the very essence of Israel. It doesn't attack Israel as an illegitimate state. It doesn't try to make that point. So I think that any comment which is designed to justify the removal of Israel as a Jewish state, to claim that Israel is illegitimate in its very essence and its essential nature, is anti-Semitic, anti-Zionist. But any other criticism, although reasonable people might disagree with it, possibly is legitimate. But it always depends on the circumstances. But I mean, it's already been said by Mark and Elisa that anti-Zionism, by definition, is opposition to Zionism. It's opposition to the Jewish right to political autonomy and self-determination, and that in and of itself it is anti-Semitic, in my view.
Thank you, Lesley Klaff, Mark Goldfeder, Lisa Lewin. You brought us to the end of the.
If I could just, there was one other question in the Q&A, which I would like to just in 2 seconds answer, if I could. It was a question about whether this whole theory would apply to converts to Judaism. And I just want to say that I do think that it would apply to converts for a host of reasons. One is that Jews believe that everybody, including the converts, religiously, they say they were all at Mount Sinai, and so they're all part of it. But even the idea, if you look at the biblical Ruth, who said when she became Jewish and followed her mother-in-law, she said, your God will be my God, your people will be my people. And there is this sense in the belief that Jews have that if you convert to Judaism, you have adopted our Jewish heritage. You are part of our Jewish people. It's like when you have families that adopt children. When they adopt children, they become their mother, they have their grandparents, they all become adopted into that family. It's the same way when they're converts to Judaism. I would argue strongly and forcefully that these legal arguments apply equally to converts to Judaism as well. We're all part of the Jewish people. I just had to answer that question. Sorry.
I wasn't planning to ignore the question, but the questioner had withdrawn the question and said he would prefer to address it with one of the speakers after. At any rate, I want to thank you, Lesley, Mark, Elisa. For our audience, thank you for joining us, and keep an eye out for notice of the next event during the month of August, when Elisa Lewin and I will be joined by Denise Katz-Prober for a deeper dive into the question of how one can use Title VI of the Civil Rights Act of 1964 to fight anti-Semitism in the schools. Thank you all, and take care.